Supreme Court Justice Clarence Thomas's lawyer says they will cooperate with an investigation of Justice Thomas by the Judicial Conference. The lawyer said, "We look forward to answering any additional questions or addressing any remaining issues with it and its staff. In the wake of these sensationalized allegations, the financial disclosure process should never be weaponized against any justice simply because any organization or anyone disagrees with the way a justice thinks, writes, or votes." Senator Sheldon Whitehouse is back with us. And Senator, this is the biggest revision of financial disclosure forms, I believe, in the history of financial disclosure forms, including senators, House members, anyone. And it's so striking to me. It's a Supreme Court justice. And repeatedly, there are explanations like this for the new revisions. And this refers to the sale of his mother's house to billionaire Harlan Crow, the house that Clarence Thomas partially owned. He said Clarence Thomas inadvertently failed to realize that the sales transaction for the final disposition of these properties triggered a new reportable transaction. This is not complicated stuff. Just one more. This is the most amazing one of all to me. Personal bank accounts at the Congressional Federal Credit Union. I still have my Senate Federal Credit Union checking account. Those accounts were inadvertently omitted in prior years due to a misinterpretation of the rules. Filer believed that personal bank accounts were exempt from reporting disclosure. Senator, what other kinds of bank accounts does a Supreme Court justice have?
I don't know. In this case, maybe he has one with Harlan Crow as his fiduciary.
I mean, it's an astonishing thing for Supreme Court justices to say, oh, you know, the details were too tricky for me.
Yeah, the two things that are frustrating about this, one is that there are so many excuses that have been made, and yet there's no means to test whether those excuses are real or not. They won't answer questions. They just say these things, in this case, through a lawyer. And there's no way to actually have a factual dispute or a fact check on whether any of that is true. And he doesn't have to make any direct statements that might imperil him if he made a false statement. So the whole process is all screwed up. And the second thing, which is even worse, is that the attempt at repair of his filings is not complete. It's not accurate. They took 1 year, 2022, but we have, and the public and ProPublica, the organization, have reported over and over again about gifts prior to that, and even in this period, gifts from other billionaires, and none of that got reported. They stopped at the 2022 form, and they didn't go back and amend any of their prior forms. And there's no explanation as to why that is appropriate. There's law about when something changes the rule and when something clarifies the rule, and there's no discussion of that law. They just posit that this changed the rule, but the actual rule change by the Judicial Conference said we are clarifying the rule, which means that he has to go back and correct all the previous ones that were wrong now that the rule's been clarified, and he didn't do that. So there's a lot of questions left, but they are not complete and accurate filings for Clarence Thomas at this point.
Well, we know who's going to stay on the case. Senator Sheldon Whitehouse, the judicial ethics crusader. Thank you very much for joining us tonight, Senator. Always appreciate it.
Thanks for having me on.
Thank you. We'll be right back.